Okay, it's precisely 7. I believe everyone who wanted to join already managed to do so. So, good evening, everyone. My name is Sophia, and on behalf of the entire organizational team of the Hague Debate Tournament, I would like to welcome you all to our today's second session. Together with my colleague Iruna, we will get you through this session. She will be keeping the time. The session will last 40 minutes. You will be notified for the participants. You will be notified for the opening speech 1 minute prior to the end of your time, and for the rest of the arguments seconds prior to the end of the argument. I would also like to ask all the participants to switch off any other electronic devices except for the device you are participating on. And now I believe we can pick the positions of the teams. The topic for today is economic exploitation of protected natural area should be prohibited. I will share my screen with you, and the first team that will be listed at the top of the list will be the team that will be representing the pro. Okay, can you see my screen? Okay, so randomize. Okay, so Dom Helder will be pro, and the Ukrainian Catholic University will be against the topic. Now I will give the teams 5 minutes to prepare, and we will see you back in 5 minutes. Good luck. Yes, perfect. Thank you. Our 5 minutes lapsed. So now I would like to invite the first speaker of Dom Helder to start with the opening speech.
Thank you. Just to be sure, am I audible and visible? Thank you. Good evening, Your Excellencies, counterpart colleagues. My name is Augusto Jesus, and along with my colleagues Bernardo Leal and Matheus Mendonca, I'll defend that economic exploitation of protected natural areas should be prohibited. At the 1992 Rio Summit, the governments recognized protected areas as economic institutions which have a key role in the alleviation of poverty and in the maintenance of the global community's critical life support systems. However, it must be noted that such an economic character does not indicate economic exploitation should be allowed. International environmental law has a fundamental role in the enjoyment of basic human rights. In fact, Darit Latta's report on peremptory norms indicated that the duty to protect the environment has a strong potential to become a jus cogens norm. Nonetheless, international standards regarding economic exploitation are most often defined on substantive soft law, such as international declarations, and the main disputes concerning the environment are only subject to an arbitral procedure or to an international court on a limited basis. The introduction of the Montreal Protocol of 1987 was a milestone considering the application of international law to the environment. But it still did not offer a precedent of great control over economic activities on natural areas. As framework conventions, the World Heritage Convention of 1972 and the Convention on Biological Diversity of 1992 play a particularly important role in the protection of natural areas in the world. However, what we seek to defend is that current international law is not able to effectively regulate state and corporation activities in the environmental field, at least within a binding manner. Thus, the prohibition of economic exploitation on protected natural areas is necessary. It is important to state that we do not defend economic exploitation should be prohibited in the environment as a whole, since, for example, the Montego Bay Convention of 1982 provides strong standards of economic activities on the high seas, although it should be noted the importance of the Antarctic Treaty System in the protection of marine resources. In contrast, legally protected areas carry a singular status within domestic jurisdictions. On instance, Brazil, as a mega-diverse country, has one of the most developed environmental legislations concerning specially protected areas, upon which no economic activity is allowed, whether for recovery processes or conservation, which includes a full compliance with human rights. It's important to note in this case that the protection of natural areas surpasses the mere prohibition of economic activities. As stated by the Inter-American Court of Human Rights in the case of the Saramacca people versus Suriname, it must be ensured the acceptance of a group living on a protected natural area prior to an economic exploration plan in order to protect collective human rights. The African Court on Human and People's Rights in the case concerning the degradation of the Niger Delta by oil operations in Nigeria. Based on the foregoing, state and corporation activities must be guided by precaution and not by reparation in the international field. For protected natural areas are important zones of environmental and human rights guarantees, and since economic exploitation has proven so far to be destructive and most often irreparable, economic exploitation on protected should be prohibited. Thank you.
Thank you very much. I would now like to invite the first speaker from Ukrainian University to take the floor.
Okay. Good evening. Can you hear me well? Okay, great. Good evening again. My name is Serhii Andruschenko, and today, along with my colleague Dmytro Fihun, we present the position that actually that the natural protected areas should not be prohibited, actually economic exploitation of such areas. First of all, we agree that such areas should be prohibited, such areas should be protected in a special way. But our statement is that there should be a special approach of such a protection. First of all, during my presentation, I have three main points. Firstly, I'd like to emphasize that the problem is actually identified wrongly. Secondly, how we are going to deal with the problem of protected areas, and the last but not least, what the consequences could be if we prohibit the economic exploitation of protected areas. First of all, we should take in mind that economic exploitation of such protected areas could be a great source of income, and actually for such special funds of supporting such protected areas. And in our situation, we have kind of different problems, since in order to save a biodiversity that we are talking about, actually, we need adequate staff, we need techniques, and we need resources. And as global estimates show that there is a great underfunded in this area, and due to such protection, due to such strict protection of economic exploitation, we have a situation where actually such areas are not protected in a proper way. For example, in Sri Lanka, according to the data of 2019, only 19% of inland waters and 11% of coastal areas managed effectively. Only such small amount of percentage is protected in a proper way. There is no efficient financing in that area. We are talking about the lack of money and not about the prohibition of economic exploitation. We would like to emphasize that, for example, in Ukraine, the amber mining is prohibited, but still we have criminal processes that such amber is mining. And the main problem is that we lack money to protect such areas. Our position is that we can solve this problem only due to the fact that to monetize that areas look at the tourism, we should take a look at the recreational values of such areas, and such spheres of economy should not impact such areas in a bad way, but it really can help to fulfill the funds of protection of such areas. Also, we should take consideration that we should adjust all the commercial operations from the tourism and actually to lead them to special funds aimed at support of such protected areas. What could be consequences if we prohibit the economical exploitation of such areas? Any government around the world have a limited budget, and all the sectors of economy actually compete within the government for the share of that budget. Thus, protected areas actually would compete with development programs, educational programs, healthcare programs, and military. That's why our position is to allow economic exploitation of protected area in order to fulfill the funds and find money to protect the areas without a need to compete with such sectors of economy. So on behalf of Ukrainian Catholic University, we state that, thank you.
Thank you very much. Give the floor back to Tom Helder to present the argument.
Just to be sure, am I clearly visible and audible? Right. Then we comprehend the counterpart's arguments, but we note that they could indicate an idea of sustainable development as an alternative to conjugate war development and environmental protection. However, the World Commission on Protected Areas does not point economic development as a main purpose of management, natural and organic use. Evidently, the environment as a set of ecosystems around the globe may be economically exploited if environmental legal principles are observed, such as the precautionary and the polluter-based principles. As an example, the International Court of Justice decided that environmental use should allow for sustainable development in the case pulp mills in the River Uruguay. Nevertheless, we strongly defend that protected natural areas carry a unique legal status in respect to the environment, in a way that the exploitation does not depend specifically on the exploitation of assets from protected areas. In fact, internationally protected areas are generally and pragmatically already barred from economic exploitation. As it regards space law, the Moon Agreement safeguards the exploitation of resources found on the Moon and within celestial bodies. Article 7 of the agreement prevents activities with non-scientific purposes which degrade or contaminate the Moon's environment. Moreover, Antarctica is designated a natural reserve devoted to peace and science to be used with scientific purposes only. As an example, the exploitation of mineral resources in Antarctica with non-research purposes is strictly prohibited under the Madrid Protocol from 1991, as it poses severe risks of environmental damage that could not be easily remediated. Thank you.
Thank you very much. Now, please, Ukrainian Catholic University, the first argument.
Thank you. Good evening. So, thank you, colleagues, for your speech. Unfortunately, we all faced with the problem when those called protected national areas were not properly taken care of. And however, I understand this problem because the resources of every state is limited and the population is growing. And talking about the shortage of resources, according to World Bank forecast, irrigated crop production is expected to grow by 80% to 2030. And we need to do something in order to meet a food demand, a global food demand. However, talking about international conventions and treaties, they all point at the limited basis of usage of such areas. And the main aim of such conventions is to protect nature while doing business, because we really support those areas. But however, we think that we can unite economically potential and those areas in one thing and do it and live harmonically with the nature. And moreover, usually legal entities are interested in long-term effect business, and we have such example in Switzerland where there are private forests which are properly provided. So that's why activity should go to the protection of the national areas, and in that way we can provide it. Thank you.
Thank you. Now I would like to give the floor back to Tom Halder.
Thank you very much. We thank the counterparts' arguments again, but undeniably, several issues arise regarding the exploitation of protected natural areas. In the sense, the fact that countries and the international community bestow a unique legal status to a natural area demonstrates us at least two things. First, the need to confer special protection to the area, and second, the need to regulate the allowed activities therein. In regards to the environment as a whole, the permanent core of arbitration is stated in the Mox Plant case that the necessity of an impact assessment can be presumed even if the likely risk is a small one within ordinary environmental conjectures. On the other hand, when countries in the international community have issued a singular legal status over a natural area, there must be a larger protection with the plain prevention of economic exploitation. Therefore, it could not be interpreted that states or international law usually take legal measures to protect a natural area in order not to prohibit economic activities, which by far have demonstrated globally the potentiality of causing great environmental damage. Nonetheless, we bear in mind that this prohibition should not be an absolute one. As every rule and every lawful prohibition, there are few exceptions which could allow, on instance, the observance of social interest and the development of ecotourism in natural areas with no environmental harm. Yet, a broad international regulation over the matter is still scarce, which surely justifies a general prohibition on the matter. Thank you.
Now floor back to Ukrainian Catholic University.
Thank you. I would like to emphasize that protected areas actually serves as a watershed that provides benefits to water down individuals, for example, farmers, ranchers, miners, and so on. For example, in Dominican Republic, the aqua conservation area actually serves as the main point of water to 17 actually cities. And for example, the range of benefits to urban dwellers is the same as well. For example, educational, recreational, and so on. I mean that we already are using such protected areas. We already actually economically exploited, but let's monetize it in a different way in order to protect such areas. For example, in order to eliminate the need for such areas to compete with such sectors of economy like military, healthcare, development systems, and so on, we should show the value of such protected areas in order to hint actually investors and governments to invest in such areas. So we need to exploitate such area in order to have better fundings and in order to protect that areas. Thank you.
Thank you very much. Now we're moving to the closing arguments. Please, Don Helder.
Just checking before my time starts, am I visible and audible? Thank you. With all that has been said, we outline our position on the necessity of prohibiting economic exploitation of protected natural areas. It is fundamental to highlight, as I stated before, that although sustainable development could be an alternative regarding the current issue and discussion, we believe international law has a binding force regarding control of legal use of natural areas. It is notable that over the years, as pointed before, countries and the international community, while creating protected natural areas, are guided by the necessity of guaranteeing human rights. Regional mechanisms demonstrate that environmental issues have continually been part of case law, such as the Pueblos Kalin and Lucono versus Suriname in the Inter-American system, the Jaghal and others versus Georgia, European system, and the case concerning the degradation of the Niger Delta in the African system. Judge Cansado Trindade stated in the Whaling Antarctica case that there has occurred, with the passing of time, a move towards conservation of living marine resources as a common interest, prevailing over state unilateral action in search of commercial profitability. In fact, although there is widespread agreement on the necessity of maintaining natural areas, the total area given protected status is frequently less than desirable. In the view of the foregoing, we sustain that the need to take actions to protect natural areas and the environment itself must be prior and not based on reparative measures. The concept of sustainable development does not suffice the recurrent inobservance of principles and field conventions on the area to hold extensive and permanent catastrophes, which will surely affect not only the present global population, but all of those that are still to come. Thank you.
Thank you. Now to the last argument of the Ukrainian Catholic University.
Thank you. So to cut a long story short, we should say that we really want to protect our nature, but we want to do it in a realistic way. We want to take some amount of taxes and maintain those national areas. We want to not to build a factory in the national protected area. We want to use those gifts like recreation zones to make windmills and something like that. And however, it's not a privilege. It's a great demand of our of today's today's reality. And if we want to save the world, we should rationally use all the resources that nature gives us. Thank you so much.
Thank you very much for all the members of both teams of today's round. And now I'd love to give the floor to our honorable judges for a bit of a feedback. I think you can pick the order. Yeah.
Well, I can start by first apologizing for arriving late. So I'm very sorry for that. I had some connection issues. but I enjoyed anyway your exchange, which was very both passionate and relevant. So my initial and partial reaction was that I really appreciated the exchange. On the substance, I'm afraid I missed maybe the initial presentations, but the subsequent presentations seem to be both good on both tone and a variation in examples could have, in both cases, been, let's say, useful. But for now, this is my limited feedback for now.
Thank you.
Thank you very much, Delphine, for your feedback. I should say that I was there from the very beginning, and I can tell you it was really, really interesting from the beginning. The arguments were really strong, but maybe some extra examples would have been required for your presentations, both presentations, I believe. Even though everything was really well documented, you relied both teams on very strong references, and that was really good. But maybe you could have seen this, the topic in, let's say, in a less national way. Maybe there was a way to consider the same topic a little bit differently. Well, as for the arguments and the exchange you had, I think it was really, really good again. Even though it was sometimes a bit difficult to hear the Ukrainian Catholic University, I should say. That's all for now. Thank you very much for your presentations.
Thank you for your feedback, Ms. Rastello.
Hi. Yes, thank you very much. It was very, very interesting. Thank you all for being so well spoken. When I was a student, I don't know if I would have been able to do that. All of you were very, very well spoken. It was very, very impressive on my side. I've noticed there was lots of research, very good references, some that I didn't know and wrote, so it's very interesting for me. I'm going to check this. For me, the arguments were very resonant and powerful, so it answered very well from one team to another. It was very interesting to see how it began and how you went on with your arguments and answering to each other. So yes, I think that's my feedback for now as well. Thank you very much.
Thank you very much. Thank you all for your feedback. Thank you all for being here. And we will be delivering the results by email once our team processes the results and can share the results with you. Thank you very much once again, and have a nice rest of the evening.
Thank you for your feedback. Thank you, our opponents. Actually, just for that round, we'll try to improve us. And thank you. It was a great time for us. It was a great pleasure to compete with you. Thank you so much.
Many thanks too. It was an awesome round for us too. Thank you.
Thank you very much. It was an awesome discussion.
Thank you.
Very glad to hear it.
See you.
Yes.